Hey y'all, my name is Carson Collins and I'm here to talk with you about Youth in Government Appeals Court. You're probably familiar with what a trial looks like. There's a judge, there's a jury, there are lawyers, and there are witnesses. Lawyers call witnesses to the stand, these witnesses testify, and then lawyers get a chance to cross-examine their witnesses. Lawyers make objections to the judge, like hearsay or speculation, and that judge can sustain or overrule the objection. In some sense, the trial is a show. This is not what appeals court is. It's not a show. It's a conversation between justices and attorneys. It's what happens after a trial. In a trial, there's a winner and a loser. But if the loser doesn't like the result, in an appeal, the losing party is saying the trial court got it wrong. Mistakes were made, and here's why. In appeals court, the appellate attorneys explain to a justice why the trial court was wrong. In Youth in Government Appeals Court, you get to do exactly what real-life appellate attorneys do. Here's an example of an appeals attorney arguing before the Texas Court of Criminal Appeals. It's one of the two highest courts in Texas. She's arguing about the validity of a search warrant.
Hey, please the court. My name is Victoria Oblon and I represent the state of Texas in this case. This is a standing case in which the defendant bears the burden of proof, not an abandonment case in which the burden is on the state. Mr. King has failed to establish that he had a reasonable expectation of privacy in a truck that he drove for work after he was removed from the truck, and the truck, his employer regained possession and control of the truck. There are two
Counsel?
Yes.
Does he still have a property interest in his phone?
He does have a property interest in his phone, and he has an expectation of privacy in the contents of his phone. And that's a very big distinction. And the contents of the phone were searched pursuant to a warrant in this case.
Well, I guess what I'm getting at is that even if I agree with you that the police can go into this car or this truck, and he has no expectation of privacy in the truck, can he still challenge the seizure of his property that's there?
No, once the expectation of privacy in the location is extinguished, then the police can seize items that are in that location. An individual, a defendant, retains an expectation of privacy in contents of items left there, whether it's a cell phone or concealed containers that may be in that location that there's a possessory or property interest in. But the cell phone itself is just like any other article of evidence, piece of clothing, that once the expectation of privacy in the location is forfeited, then the police have the right to seize those items.
Did you notice that almost as soon as she started speaking, the justices interrupted? They have questions and she has answers. The justices will ask her about the hardest, most complicated part of the law. And she tries to convince them that her interpretation of the law is correct. And when she's done with her argument, the other side will stand and try to convince the justices that she's wrong. So what exactly will you do in appeals court? Well, you'll be part of a two-person team. First, y'all want to print the case materials available on the Texas Youth in Government website. The packet is divided into two main parts. First, the story with the facts explaining what happened, and second, the case law, what other justices have decided about the issues at hand. You'll read the material, you'll think about how other cases apply to our case, you'll talk it over with your partner, your YG coach, your friends, your family, and then when you're ready, you'll write a brief outlining in written form your arguments. Now, remember the attorney we saw earlier arguing before the justices? On the day of the district meet, you'll do the exact same thing. You'll have a conversation with your justice. Each team gets 30 minutes, so each team member will speak for about 15 minutes. You'll stand up and make your argument. The student justice will interrupt with difficult questions about the law, and you'll answer those questions. Take a look. May it please the court. My name is Carson Collins, and I and my co-counsel Abigail Lovins represent the appellee in this case. In my time before the court, I will demonstrate appellant Larry Bridges' constitutional rights were not violated when he was convicted of the attempted murder and aggravated assault of Thomas Hutton, because the court's admission of Hutton's out-of-court statements did not violate his Sixth Amendment right to confrontation. The Sixth Amendment bars the admission of testimonial statements without confrontation, and the case of Crawford v. Washington elaborates, explaining that the only way to determine the veracity of a statement is through confrontation at trial. But there is an exception when the statements are not testimonial.
Well, counsel, what does it mean for a statement to be testimonial?
Well, the cases of Davis v. Washington and Michigan v. Bryant lay out our determination for whether or not a statement is testimonial. And these two cases lay out the following criteria. If the primary purpose of a statement is to assist in an ongoing emergency, then it is not considered testimonial and thus it can be used in court.
So, counsel, what was the primary purpose of Hutton's statement in this case?
The primary purpose of Hutton's statement was to assist in an ongoing emergency. And we see this when we compare the facts of the case, of our case, to the facts of Davis v. Washington and Michigan v. Bryant. First, we'll look at Davis. In the case of Davis, Michelle McCautry called 911 and told the operator that Davis had beaten her and then left. At trial, McCautry did not testify, but the 911 recording was admitted. Davis appealed this decision because he believed that the 911 recording was a violation of his Sixth Amendment right to confrontation. The Supreme Court, however, disagreed with him and ruled that because the 911 recording was considered an emergency, they did not violate his Sixth Amendment rights to confrontation. Appeals court is rigorous. It's complex, it's real life, and it's fun. If you like grappling with complex ideas, thinking on your feet, and trying to convince other people that your opinion is right, then you'll love appeals court. This is the place for you.